Alrighty, welcome to the final episode about criminal procedure. We've covered a lot of material throughout the semester, and this final episode is going to conclude by discussing the Sixth Amendment right to counsel. We've talked about the distinctions between Fifth Amendment right to counsel and the Sixth Amendment right to counsel. Now we are going to be focusing primarily on what types of charges require counsel, and then also we are going to be talking about what types of proceedings require counsel, and then we will conclude by summing up the sources of the right to counsel based on the Fifth Amendment and the Sixth Amendment, just to provide one last summary of how that all works. So let's start with the type of charges that require the right to counsel. Well, there are two significant cases of Powell versus Alabama and Betts versus Brady. These cases begin to outline when defense counsel is required to be provided to the defendant. In Powell, it's a pretty famous poor result of case. There were 9 black young men who were convicted for raping 2 white women, and they were sentenced to death. Their trial, you could say, was anything but fair. Counsel was technically appointed, but there was no official lead counsel, and it was really whoever wanted to pick up the case could pick up the case, and nobody did that until like the day before trial, which that trial only lasted for a day anyways. When this case got to the Supreme Court, at that point they did have, the Supreme Court said that a lead counsel was required, considering the nature of the crime and the sentence that the defendants were facing, specifically rape being the crime and the death penalty for the sentence. Now, in Betts, what happened here is that the court determined that special circumstances did not consider the financial state of the defendant, but instead considers the nature of the crime, which means in Betts, counsel was only required to be appointed if the defendant was charged for rape or murder. It didn't consider whether or not the defendant was poor to be appointed. So, if you commit a lesser offense and you're poor, no counsel. You commit a higher offense and you're poor, you do get counsel. This, though, was altered in a case called Gideon versus Wainwright, which we will talk about in just a minute. But I do want to mention one last case, which is Johnson versus Zerbst, which says that the right to counsel was constitutionally mandated in federal court, and Gideon versus Wainwright kind of extends that to states as well through the process of incorporation. So in Gideon versus Wainwright, what happened here is that there was an individual. He had broken into a pool room with the intent to commit a misdemeanor, either to commit damage or to steal something, whatever it was. But breaking and entering is a burglary, and it is a felony. But the courts here denied him the right to counsel, and he was forced to argue his case by himself. Actually, that might be the arguing of the case by himself might be a different one, but essentially he was denied the right to counsel, and the court here says, the Supreme Court says that this was wrong. A right to counsel should have been provided. The reasoning for this, the rule is that a right to counsel is a fundamental right that is protected by the Sixth Amendment and incorporated against the states by the 14th Amendment. So, counsel needs to be provided to those who can't afford one, regardless of the charged crime. In Betts, the court determined that the right to counsel was not a fundamental right. In this case, however, the court is going to overturn Betts and say that the right to counsel is a fundamental right. And because it's a fundamental right, the failure to deny Gideon that right to counsel after he showed that there was a need for one financially, that was unconstitutional. A lawyer is so critical because it is necessary for a fair trial. It's pretty hard to argue a case without a lawyer who has expertise and knowledge in how to litigate an issue. This is really evident too because after this was remanded, Gideon was provided a lawyer, and his case resulted in an acquittal. Harlan concurs that the lawyer is necessary, but says that there is no need to overturn bets. Instead, all you have to do is just define special circumstances based off of how substantial the prison sentence is. Here, the prison sentence was of 5 years, and so it would have qualified as a special circumstance in bets according to the according to the concurrence, and so it would have ended up being reversed anyways. Okay, now we've got an in-rate advisory opinion to the governor. What happened here is that the governor of Rhode Island asked the court whether a right to counsel was required when the defendant was charged with a crime that may not result in incarceration. The simple response is no. Essentially, the right to counsel extends to all criminal cases, felony or misdemeanor, but it does not extend to crimes that do not result in incarceration. This is because incarceration is a removal of fundamental rights. So if there is no right to counsel for taking a breathalyzer test, which might result in losing a driver's license, but not incarceration, well, then there's no right to counsel there. Even though, for this example, a driver's license is important, there's no fundamental right to drive. You're not being incarcerated, which is, so there is no right to counsel there. The dissent in this case, though, argues in this advisory opinion to the governor that the federal rule adopted in this case is going to be impractical. For instance, the rule requires the right to counsel at the beginning of the litigation, so the court is required to guess whether jail time is going to occur at the end of trial, because we don't know what the sentence is going to be, whether it's going to be incarceration or if it's going to be something else at the beginning of trial, but now we're being asked to guess what that potential result could be. Okay, then we have another case, Alabama versus Shelton. What's our rule here? Well, counsel needs to be provided in the event that the defendant is to face actual incarceration. That is, counsel must be appointed in the absence of a waiver to a defendant if they have been given a suspended sentence. That's the specific holding in that case. So what happened to Shelton? Well, Shelton was charged and convicted with third-degree assault and unsuccessfully represented himself. He appealed, he lost again, and he lost even after he was being warned of the potential issues of self-representation. Shelton was provided a sentence of 30 days of jail, but before this could occur, the sentence was suspended and conditioned on serving 2 years of unsupervised probation and paying certain fees. So what is a suspended sentence? Well, a suspended sentence is saying your sentence is jail time, but instead of doing jail time, you're going to be put on probation. If you violate your probation, then you'll go to jail, and then you'll fill that sentence that has thus been suspended. If you abide by probation, well, then you don't need to go to jail at all. So, is this allowed? Do you need counsel in order to do a suspended sentence? And that's really the question here. Well, in the event, according to the majority, of a breach of the probationary conditions, the defendant is going to be subject to incarceration, actual incarceration, based on the actual crime, not based on the breach of probation. It's not being sent to jail because he breached probation. It's being sent to jail because the person committed a crime and then violated probation. So if he's in prison for the crime without having provided a waiver of counsel, then this is a blatant violation of court decisions in Singer, I can't pronounce the case, and Scott versus Illinois. The dissent is going to argue in this case, though, that everything is going to be hypothetical until the defendant actually breaches the probationary conditions, which might be something that never happens in the first place. And so this is expensive and pretty impractical to require a counsel for a sentence that might end up being, jail time, incarceration time, that is hypothetical until something happens, especially for minor crimes. So those are our charges requiring the right to counsel. In other words, right to counsel is required regardless of the crime, felony, or misdemeanor. And it's going to be required whenever there is the potential for actual incarceration. And this is going to be the case regardless of the financial standing of the individual. So what about proceedings that require counsel? We have a case, Rothgary versus Gillespie County in Texas. What is our rule? Well, prosecution commences when the machinery for prosecution begins. This is going to be either a formal charge, preliminary hearing, indictment, information provided to the defendant, or arraignment. After the proceedings have begun, the attorney is only required at the critical stages of those proceedings. We talked about a critical stage in a previous episode, and that was going to be in your classic lineup. Those other examples of critical stages are going to be post-indictment lineups, post-indictment questioning, preliminary hearings, sentencing. The critical stage does not include taking DNA samples, a photo array, post-arrest but pre-indictment probable cause hearings, and fourth and finally, a first appeal after the trial, and then also any probation revocation hearings. Because at that point, that right to counsel has expired. So what happened to Rothgary, or Jerry Rothgary? We'll just go with that. Well, he was arrested with possession of a firearm, and the arresting officer believed that he was a felon because the person had a record and it was improperly recorded saying that he was a felon. For this reason, he was taken to a magistrate for proper charging and probable cause because the officer did not have a warrant. In this state, it's called a 1517 hearing. And at the hearing, the defendant requested counsel, but he waived it when he learned that it would delay in posting bail. Later in the jail, he requested an attorney several times, but the attorney was not officially provided to him until he had spent several weeks in jail and had been indicted. Now here, eventually an attorney was appointed to him, and it resulted in his indictment being dismissed because he wasn't a felon, it was misreported, so on and so forth. Now the state here argues that the prosecution required the prosecutor to make a showing of commitment to begin prosecution. The court does disagree, though, and says that prosecution begins means it attaches at the 1517 hearing because he had been accused at that time and been bound, and his bond had been set in. In other words, the machinery of prosecution began, so the right to counsel also began there. The court also determined, though, that the right to counsel had not been violated in this case because eventually he was given his counsel and the right to counsel doesn't have any specific timeline. Then we have People versus Larson, which says that the right to, what happened to Larson? He was charged with murder, and he claimed not guilty by reason of insanity. So the court ordered a therapist to determine whether or not Larson was insane at the time of the crime. Larson's attorney was not informed about his appointment with the therapist, and so the attorney was not present during the meeting and the report so that he was not insane at the time of the crime, and that was used against him at trial. Well, Larson is arguing that this is a critical stage of the litigation that required his attorney to be present. Well, that's really the biggest question here, and the court says that meeting with a therapist is not going to be a critical stage unless if it is regarding a capital case. That's going to be the typical rule amongst courts. Okay, so that's everything as far as the right to counsel in proceedings. The rule there is counsel attaches once the prosecution begins. It detaches once it finishes, and essentially prosecution begins once a person is taken before court. But the right to counsel is only required in those critical stages of the litigation. Okay, so what are our different sources of the right to counsel? Well, you have the Fifth Amendment, right to silence, that also includes the right to counsel with the purpose to retain and preserve that right to remain silent. In other words, according to the Fifth Amendment, your right to counsel is to preserve your right to remain silent. Then you have due process and equal protections for appeal that preserves the right to counsel. Then you have a statute or potential statutes that can provide protections of the right to counsel that is greater than the Sixth Amendment right to counsel. And then finally you have the Sixth Amendment right to counsel, but there are those three requirements, which is the charge must be seriously enough to qualify the right, the prosecution must have commenced, and then the litigation must be in a critical stage in order for the counsel to be there as well. And that is everything as far as criminal procedure. Way to end it on a high note. That's everything for criminal procedure. It's been a fun semester. My test is tomorrow. I've got a lot of studying to do, so wish me luck. You won't be seeing this until after the test is long since passed, though. Anyways, have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.